Have you ever found yourself just swimming through a sea of complex legal or financial terms, wishing you had a clear map,
Oh, definitely.
especially when it comes to something as, well, as crucial as bankruptcy?
Yeah.
Well, consider us your expert navigators today.
It's easy to feel lost in that language, isn't it? All the jargon. But we're here to translate, yeah, to break down the mechanics piece by piece so you gain genuine clarity and hopefully confidence in understanding what's really going on.
Exactly. Our mission with this deep dive is to cut through all that jargon, extracting the most vital insights from a stack of comprehensive sources. Think of it as your shortcut to being genuinely well-informed. We're hoping to pack it with surprising facts and really practical understanding. We've got an incredible foundation of material, really solid stuff, and our goal is just to distill the most impactful knowledge for you. So let's start with the absolute core. What is bankruptcy fundamentally? Why does this legal pathway even exist?
Right. At its heart, federal bankruptcy law serves a really powerful purpose. It's designed to offer the law calls it an honest debtor a fresh start financially.
A fresh start, okay?
Yeah, and it achieves this by legally discharging or wiping out most of their debts. It's a structured legal process, you see, designed to manage overwhelming financial obligations. It provides a way out when debt becomes truly unmanageable. It's basically the law's way of ensuring people can recover and, contribute again.
And it's definitely not a one-size-fits-all solution, is it? Our sources lay out, I think, 6 basic types of bankruptcy cases under federal law.
That's right, 6 main types.
You might have heard of a few, but understanding their core concepts is key. There's Chapter 7, which people often call liquidation, essentially selling off assets to pay creditors. Kind of a clean slate approach.
The most common one people think of.
Yeah. Then Chapter 9, that's specifically for municipalities, right? Helping cities or counties reorganize debt.
Correct. Not for individuals or businesses.
Then Chapter 11, that focuses on reorganization, usually for businesses, allowing them to keep operating while they restructure their finances.
Keeping the doors open.
Chapter 12 is a specialized one for family farmers with regular income.
A very specific group, yes.
And Chapter 13, that's an adjustment of debts for individuals who have regular income. Typically involves a court-approved payment plan.
Paying back over time.
And finally, Chapter 15. This covers ancillary and other cross-border cases. Deals with international insolvency, which sounds complicated.
It has its complexities, definitely. It connects different country systems. But that's a crucial overview. If we zoom out, connect this to the bigger picture, knowing these main types gives you a solid conceptual foundation. For our deep dive today, we'll mostly focus on the ones you'll hear about most often for individuals and businesses, Chapter 7, 13, and 11.
Okay.
And then we'll take a look at Chapter 15, too, because it has that unique global angle.
Right, let's start by dissecting Chapter 7 then. It's often the one, like you said, that comes to mind when someone mentions bankruptcy. What truly unfolds in a Chapter 7 case?
Okay, Chapter 7. A trustee is appointed by the court.
A trustee, right.
And this trustee's main job is to gather and liquidate, which just means sell off the debtor's non-exempt assets.
Non-exempt, so not everything gets sold.
Exactly. There are exemptions, things you get to keep. We'll touch on that. But the money generated from selling the non-exempt stuff, that goes towards paying creditors as much as possible.
And the ultimate goal here, for individuals anyway.
For individuals or married couples filing jointly, their debts are discharged. That means they're relieved from personal liability for most of what they owe. It allows that fresh start we talked about.
Most debts. Okay, so some stick around.
Yes, definitely. There are critical exceptions we absolutely need to explore later, but for artificial entities like corporations, they don't get a discharge in the same way. They're typically dissolved, and their debts are effectively wiped out as part of that dissolution process.
Got it. So individuals get a fresh start, corporations kind of just end.
That's a simple way to put it, yeah. Now, in contrast, you have Chapter 13. That's known as adjustment of debts of individuals with regular income. This is really for people who want to keep their assets, like their house or car, perhaps.
So not the liquidation route.
Right. Instead of selling everything, the debtor proposes a repayment plan. This plan often lasts 3 years, but it can go up to a maximum of 5 years.
3 to 5 years.
Yeah. A Chapter 13 trustee still oversees the plan and the payments to creditors. And once the debtor successfully completes all the payments under this plan, any remaining eligible debts are then discharged.
Okay, so Chapter 7 is more about a quick, clean slate through liquidation. Chapter 13 is a longer managed path repaying over time, holding onto property.
Precisely.
And this leads us to what seems like a really key distinction. The role of the trustee in these different chapters.
That's a very perceptive point. Because in a Chapter 11 reorganization case, which, remember, is primarily used by businesses, though individuals can file it too, a trustee is typically not appointed.
Oh, interesting. No trustee.
Usually not. The debtor, whether it's a company or an individual, generally remains in possession of their assets. They're called the debtor in possession.
Debtor in possession. Okay.
And they continue to operate the business. The core idea is to develop a reorganization plan, which essentially outlines how debts will be restructured and paid over time, differently than originally agreed. The business keeps going, and creditors get paid according to this new court-approved plan.
So let me try and summarize that key difference for you listening. A trustee is basically required for Chapter 7 and Chapter 13 cases.
Right.
But generally, the debtor themselves acts like the trustee in a Chapter 11 reorganization, managing their own assets.
That's right.
Unless the court steps in and decides one is needed, maybe if there's mismanagement or something.
Exactly. The court can appoint one if there's cause, but the default is debtor in possession. It's really geared towards maintaining business continuity.
Okay, that makes sense. Now that we've sketched out the main types, let's get into eligibility. Who can actually, be a debtor in one of these cases?
The basic rule is pretty broad. Any person who resides or has a domicile, a place of business, or property in the United States can be a debtor under the Bankruptcy Code.
And person means?
Well, the code defines person quite widely. It includes individuals, obviously, but also partnerships, corporations, even unincorporated associations.
Gotcha. But there are some specific boundaries, right? Like not everyone can file Chapter 7.
Correct. There are some specific exclusions, especially for Chapter 7. Certain heavily regulated entities, think railroads, banks, insurance companies, savings and loans, small business investment companies, they generally cannot file under Chapter 7 liquidation.
Okay, so those big financial players have different routes.
Usually, yes, through other regulatory mechanisms. However, for Chapter 11 reorganization, most of those exclusions don't apply. Pretty much anyone who's eligible for Chapter 7 plus railroads can typically file under Chapter 11.
Even railroads? Okay.
Yes, and it's an important nuance to remember. While we often associate Chapter 11 with, big corporations in the news, individuals are absolutely eligible to seek relief under Chapter 11 too, especially if their financial situation is particularly complex.
Right. Okay, let's talk about how a case actually kicks off. It can be voluntary, meaning the debtor files, or sometimes involuntary, where creditors push for it. How does a voluntary case begin?
A voluntary case is pretty straightforward to start. The debtor simply files a petition for relief with the appropriate bankruptcy court.
Just file the paperwork?
Essentially, yes.
Yeah.
And here's a fact that surprises many people. A debtor doesn't actually have to be insolvent to file for bankruptcy.
Really? Not insolvent?
No, insolvency, technically meaning liabilities exceed assets, isn't a requirement to file voluntarily.
Huh. So that raises an important question, doesn't it? If you're not technically insolvent, why file? And maybe more importantly, what stops someone from, say, abusing the system?
That's a critical point, and that's where the means test comes into play, specifically for Chapter 7 cases filed by individuals.
The means test. Okay, heard of that.
The means test is basically designed to ensure that Chapter 7, the liquidation chapter with the quick discharge, is primarily for those who genuinely cannot afford to pay back at least some of their debts through a repayment plan, like in Chapter 13.
So it screens people.
In a way, yes. It's a calculation. It looks at your current monthly income, compares it to the median income for a family of your size in your state, and then deducts certain allowed expenses. If your income is above the median and you have enough disposable income after those expenses based on certain thresholds, there's a presumption of abuse.
Abuse meaning?
Meaning it's presumed you could actually fund a Chapter 13 repayment plan. In that case, the court might dismiss your Chapter 7 case, or you might have the option to convert it to Chapter 13.
Ah, okay. So it steers people who can pay something towards the repayment chapter.
Exactly. It reserves Chapter 7 for those who truly need that liquidation fresh start.
And just a practical tip for you listening. If you're married, our sources mentioned you can file jointly. This can save on duplicate court fees and streamline the process. Seems like a small detail, but it could matter.
Absolutely. Filing jointly is very common.
And once that voluntary petition is filed with the court, it instantly acts as an automatic order for relief. That basically sets the whole bankruptcy process in motion, right?
That's correct. The filing itself constitutes the order for relief in a voluntary case. Things start happening immediately.
Okay. Now, what about the flip side? When creditors are the ones pushing a debtor into bankruptcy, what are the rules for these involuntary cases?
Involuntary petitions can be filed by unsecured creditors, but only under Chapter 7 or Chapter 11, not Chapter 13.
Only 7 or 11. Got it. And what's the reason they can do this?
The primary grounds is that the petitioning creditors have to demonstrate that the debtor is generally not paying their debts as they become due.
So, falling behind on bills, basically.
Essentially, yes, a general pattern of non-payment. What's interesting here, again, is that the creditors don't necessarily have to prove the debtor is technically insolvent, just that they're not meeting their current obligations.
Insolvency isn't always the key trigger. Who's exempt, though? Can creditors force anyone into bankruptcy?
No, there are important exemptions. Farmers and nonprofit charitable organizations generally cannot be forced into bankruptcy involuntarily by their creditors.
Farmers and charities are protected. Okay.
Now, the rules around who exactly must join an involuntary petition can seem a bit, well, intricate.
Yeah, I bet.
Essentially, it depends on how many creditors the debtor has and the amount of debt involved. The petitioning creditors must hold unsecured claims, meaning claims not backed by collateral that are not subject to a legitimate dispute. And these claims have to total at least a certain amount, currently $18,600.
$18,600 in undisputed unsecured debt.
Right. Now, if the debtor has fewer than 12 creditors in total, then just one or more creditors who are owed at least that $18,600 amount combined can file the petition.
Okay, fewer than 12, one creditor might be enough.
Yes, if they meet the dollar threshold. But if the debtor has 12 or more creditors, then the rule changes. At least 3 creditors, who together are owed at least $18,600 in that undisputed unsecured debt above any collateral they might hold, must join together to file the petition.
3 creditors if there are 12 or more total. That's specific.
It is. Let's try an example to make it clear. Imagine Dee owes money and isn't paying. She has 4 creditors. Alex, who she owes $17,000 unsecured. Bob owed $4,000 unsecured. Carla owed $4,000 unsecured, and Sam owed $18,000, but that loan is fully secured by Dee's car.
Okay.
Now, let's say Dee has fewer than 12 creditors total. Alex alone is owed almost the $18,600 threshold, but not quite. Bob and Carla together only have $8,000 in claims. Not enough. Sam can't petition because his debt is secured. So in this scenario, if Alex's claim was, say, $19,000, Alex alone could file. But if Dee had 12 or more creditors total, you'd need 3 creditors to join. Alex, Bob, and Carla together are owed $25,000 unsecured, $17K plus $4K plus $4K, which is over the $18,600 aggregate threshold. So those 3 could join together to file an involuntary petition. Sam still can't be one of the petitioners because his claim is secured.
That example really helps clarify those requirements. Thanks. And it's important for you listening to remember these specific dollar amounts and creditor number rules, they only apply to involuntary petitions.
Correct. Not relevant if the debtor files voluntarily.
So, okay, a petition gets filed voluntary or involuntary. What's the immediate, most impactful effect for the debtor? You mentioned something starts happening immediately.
Yes, the automatic stay. This is huge. The moment a bankruptcy petition is filed, an automatic stay immediately goes into effect against most creditors.
Automatic stay. Sounds like a freeze.
It basically is. Think of it as an instant court-ordered halt on almost all collection efforts. Lawsuits stop, foreclosures stop, repossessions stop, wage garnishments stop. Those relentless phone calls and demand letters, they have to stop too.
Wow, that's immediate relief. Almost unimaginable for someone under that pressure.
It's incredibly powerful. It gives the debtor breathing room.
But, and this seems critical, it doesn't stop everything, right? Are there exceptions?
Absolutely crucial point. Yes, there are significant exceptions. The automatic stay does not stop criminal prosecutions. It doesn't stop legal actions related to establishing paternity. And very importantly, it does not stop actions to establish or collect domestic support obligations. Alimony, spousal support, child support, those continue.
Okay, so criminal matters and family support obligations proceed regardless. Good to know.
Very important distinction. Now, after filing, the debtor has specific jobs to do, mainly filing a whole bunch of documents with the court. It's quite a bit of paperwork.
Like what kind of documents?
Well, a complete list of all their creditors, names, addresses, amount owed, a detailed schedule of all their assets and liabilities, what they own, what they owe, a statement of their current income and expenditures, a statement of financial affairs, kind of a history, plus copies of recent pay stubs and their federal tax return for the most recent tax year.
Okay, quite comprehensive. Full financial disclosure.
Exactly. And any unpaid taxes from that last return generally need to be paid for the case to proceed smoothly.
And you mentioned deadlines earlier.
Yes. For individuals filing a voluntary Chapter 7, this paperwork is critical. If these required schedules and statements aren't filed within 45 days after the petition date, the case is automatically dismissed on day 46.
Wow, automatic dismissal. That's a strict deadline you absolutely need to remember.
Very strict. No wiggle room there, usually.
Okay, so petition filed, stay is active, documents are submitted. What's next?
Following these initial steps, usually within about 20 to 40 days after the order for relief, there's something called the Section 341 meeting, which is often just called the Creditors meeting.
The creditors meeting. Sounds potentially intimidating.
It can feel that way, but it's usually pretty routine. All interested parties, the creditors, the trustee assigned to the case, and the debtor get notice and have the right to attend. The debtor is required to attend and answer questions under oath, usually from the trustee, about their finances and the filed documents. Creditors can ask questions too.
Okay, so a chance for everyone to get information. Now, when someone files for bankruptcy, what exactly gets swept into their bankruptcy estate, the pot of assets available to pay creditors?
Good question. Generally speaking, the bankruptcy estate includes basically all of the debtor's property, both real estate and personal property, wherever it is, that they have a legal or equitable interest in at the time the case is commenced, the moment the petition is filed.
Okay, everything owned at the time of filing.
Pretty much. But it also includes some things acquired after filing. For instance, any income or profits generated from that estate property, like rent from a rental property owned at filing that comes in within 180 days after filing, that also becomes a part of the estate.
Within 180 days after filing. Interesting.
Yeah, and here's a detail that really surprises a lot of people. If you receive certain types of property, specifically from a divorce decree and inheritance, or as a beneficiary of a life insurance policy, within 180 days after you file your bankruptcy petition.
Even after filing.
Yes, within that 180-day window, that property also becomes part of your bankruptcy estate and potentially available to your creditors.
Wow. So if you file bankruptcy today and say your rich uncle passes away 100 days from now, leaving you money, that inheritance goes into the bankruptcy estate.
That's generally how it works, yes. It's a significant look-forward period for those specific types of property acquisition.
Good to know. What else can the trustee do with property?
Well, the trustee also has the power regarding existing leases. They can decide to assume a lease, meaning the estate takes it over, assign it to someone else, or reject it entirely, depending on what's best for maximizing value for the creditors.
Okay, so that's what goes in. What about the flip side? What's excluded? What do you get to keep out of the estate?
The main exclusion is earnings from services performed by an individual debtor after the petition is filed. Your post-petition wages, generally, are yours to keep and not part of the Chapter 7 estate.
Okay, so the money you earn after filing is safe, usually.
Generally, yes, in Chapter 7. Chapter 13 is different, as post-petition income funds the plan. Also, certain basic necessities are often excluded or exempted under federal or state law, things like necessary clothing, household goods up to a certain value, medical devices. These exemptions vary by state, though.
Right, exemptions. We mentioned those earlier. Now, the trustee, they're not just selling assets, are they?
Yeah.
Our sources indicate they have some serious powers to protect the estate and ensure fairness.
Oh, absolutely. The trustee has several powerful tools, often called avoiding powers.
Avoiding powers.
Yes, powers to avoid or undo certain pre-bankruptcy transactions. One is the hypothetical lien creditor power. It's a bit legalistic, but basically the law treats the trustee as if they had obtained a judicial lien on all of the debtor's property the very instant the bankruptcy case was filed.
Okay, and what does that mean practically?
It means the trustee's claim to the property generally takes priority over almost all unsecured creditors who didn't already have a perfected lien before the bankruptcy. It gives the trustee a very strong position to gather assets for the estate.
So they jump to the front of the line ahead of many others.
In essence, yes, regarding the debtor's property. Then there's the power over fraudulent transfers. This is really important. The trustee can go back and recover property that the debtor transferred away within 2 years before the bankruptcy filing if that transfer was fraudulent.
2 years. And what makes a transfer fraudulent? Is it always about hiding things?
Not necessarily intentional hiding, although that's one way. A transfer can be considered fraudulent under the code in 2 main ways. First, if it was made with the actual intent to hinder, delay, or defraud creditors. That's the hiding assets scenario.
Okay, intent to defraud.
But second, and this is crucial, it can be what's called constructive fraud. This happens if the debtor received less than reasonably equivalent value in exchange for the property they transferred and they were insolvent at the time of the transfer, or became insolvent because of it. No bad intent needed here.
Less than fair value while insolvent.
Exactly. So remember Dee giving her friend a $5,000 cash gift while she was insolvent, just before filing. Even if Dee had no evil intent because she received nothing of value in return while insolvent, the trustee could likely recover that $5,000 from the friend. It protects the creditor pool.
Got it. So the trustee can claw back assets given away unfairly or with bad intent, but they can also disaffirm preferences. What does that mean? Sounds different from fraud.
It is different. The power to avoid preferential payments or preferences is another key tool. The underlying idea here is fairness among creditors. The law wants to prevent a debtor on the verge of bankruptcy from picking and choosing which of their existing creditors to pay off, giving those favored creditors an unfair advantage over others.
So no playing favorites right before filing.
Exactly. When a payment is deemed a preference, the trustee can recover that payment from the creditor who received it, and that money goes back into the bankruptcy estate to be distributed according to the priority rules we'll discuss.
Okay, so what makes a payment a preference? There must be rules.
There are several specific elements, and all usually need to be met. 1, it has to be a transfer of the debtor's property to or for the benefit of a creditor.
Okay, payment to a creditor.
2, it has to be on account of an antecedent debt, meaning a debt that was already owed before the transfer was made, not for something bought right then.
Old debt, got it.
3, the transfer must have been made within 90 days before the date the bankruptcy petition was filed.
90 days. That's the window.
Yes, the standard window. However, if the creditor receiving the payment is an insider, like a relative, a general partner, or an officer or director of a corporate debtor, then that look-back period extends to 1 full year before filing.
1 year for insiders.
Okay. 4, the transfer must have been made while the debtor was insolvent. And importantly, the law presumes the debtor was insolvent during the 90 days immediately before filing. The creditor would have to prove otherwise.
Presumed insolvent in those 90 days.
Correct. And 5, the transfer must result in the creditor receiving more than they would have received if the transfer hadn't happened, and they instead just received a distribution from the debtor's Chapter 7 bankruptcy case.
They got a better deal than they would have in bankruptcy. That's the key.
That's the essence of it. It has to improve their position relative to other creditors. Let's use those examples again. Remember Deanna, the retailer. If she owed Carla money from months ago, antecedent debt, and just days before filing bankruptcy, within 90 days, presumed insolvent, Deanna grants Carla a security interest in all her inventory, which Carla properly records. Perfects. This transfer likely is a preference. Carla got security for an old debt, improving her position dramatically compared to other unsecured creditors just before bankruptcy. The trustee could likely avoid that security interest.
Okay, that makes sense. Giving security for an old debt looks preferential.
Right. But contrast that with Deanna paying Alex, her supplier. If Alex delivers new goods, and Deanna pays Alex for those specific goods upon delivery, or very close to it, that's generally not a preference. It's considered a contemporaneous exchange for new value. Deanna got new goods of equivalent value right when she paid. The estate wasn't diminished unfairly.
So simultaneous exchange is okay. It's paying old debts disproportionately. That's the issue.
Exactly. The timing and the nature of the exchange are crucial here.
And let's clarify that greater share point. What about paying a creditor who already has collateral, a secured creditor?
Right. Generally, payments made to a fully secured creditor within the preference period are not considered preferences. Why? Because that creditor would have been entitled to the value of their collateral anyway in a Chapter 7 liquidation. The payment didn't really give them more than they were already entitled to.
Okay, so paying the secured car loan isn't usually a preference.
Correct, assuming the car's value covers the loan. Also, there are other important exceptions. For example, payments made in the ordinary course of business or financial affairs of the debtor and the creditor are generally not avoidable preferences.
Ordinary course. Like what?
Think regular monthly payments on utilities, rent, or maybe routine supplies bought on standard credit terms. The law doesn't want to disrupt normal, ongoing business relationships unduly.
Okay, that makes practical sense. Now, once the trustee has gathered all the assets, potentially clawed back fraudulent transfers or preferences, how do creditors actually stake their claim to get paid from this estate?
To get paid from the estate, unsecured creditors generally must file a document called a proof of claim with the bankruptcy court. If the debtor is a corporation, shareholders might file a proof of interest.
Proof of claim. Okay.
This document details who the creditor is, how much they're owed, and the basis for the debt. If nobody objects to the claim, it's generally deemed allowed. And here's a critical point for unsecured creditors. If you fail to file your proof of claim by the deadline set by the court, you generally cannot participate in the distribution of the estate's assets. You miss out.
So filing that proof of claim on time is absolutely essential for unsecured creditors.
Absolutely. However, a creditor with a perfected security interest, like a bank with a properly recorded mortgage on a house, is treated a bit differently. Their lien on the collateral generally survives the bankruptcy process, even if they don't file a proof of claim. They still have rights to their collateral.
Right. Their security interest gives them a stronger position. Okay, let's move towards the end game, especially for individuals. The whole point is that fresh start. What can actually stop that from happening? Or what kinds of debts just stick around no matter what?
There are two main concepts here. First, there are objections to discharge. These are serious issues that can prevent the debtor from receiving any discharge of any debts in that particular Chapter 7 case. The whole fresh start is denied.
Wow, deny the whole thing. What triggers that?
These are usually related to debtor misconduct or status. For example, the debtor isn't an individual. Corporations don't get a Chapter 7 discharge, they dissolve. Or the debtor committed serious bankruptcy crimes like fraudulent transfers or concealing property with the intent to defraud creditors, either in the year before filing or during the case itself.
Okay, fraud is a big one.
Huge. Also, unjustifiably failing to keep adequate books and records, making it impossible to figure out their financial condition. Or, and this is a common one, if the debtor received a discharge in a prior bankruptcy case filed within the last 8 years.
8 years. So if you get a Chapter 7 discharge today, you have to wait 8 full years before you could potentially get another one. That's a long time.
It is. It prevents people from repeatedly using bankruptcy too frequently. Those are grounds for denying the entire discharge.
Okay, so those block the whole fresh start. But then there are specific debts that don't go away even if you do get a general discharge, right?
Exactly. These are the exceptions to discharge. This is a really, really critical point for you to understand. Even if a debtor successfully completes their bankruptcy and receives a discharge order, not all debts are wiped out. Certain categories of debt survive the bankruptcy, meaning the debtor remains personally liable for them.
They stick with you.
They stick with you. And our sources gave us that handy acronym to help remember the major ones. WAFTED.
WAFTED, right. Let's unpack that for everyone.
Okay. W is for debts arising from willful and malicious injury caused by the debtor to another person or their property. Think intentional torts, not just accidents or negligence.
Intentional harm.
A is for alimony, maintenance, or support obligations owed to a spouse, former spouse, or child. These domestic support obligations are almost always non-dischargeable.
Family support is protected.
Absolutely. F is for debts incurred through fraud, false pretenses, or false representations. Also includes debts from embezzlement or larceny. If you lied to get the loan, you probably still owe it.
Debts based on fraud. Makes sense.
T is for certain taxes. Generally, recent income taxes, payroll taxes, things like that are not discharged. Older taxes might be, but there are complex rules.
Taxes are tricky.
Very. E is for educational loans, student loans. These are notoriously difficult to discharge. You typically have to prove an exceptionally high level of undue hardship, which is a very tough standard to meet.
Student loans usually survive.
Usually. And finally, D is for debts that were not scheduled by the debtor in their bankruptcy petition, unless the creditor happened to find out about the case in time to file a claim. Basically, if you don't list a debt, it likely won't be discharged. Honesty and completeness are key.
WAFTED willful injury, alimony support, fraud, taxes, educational loans, debts undisclosed. That's a great way to remember the big ones that stick around.
It covers the most common exceptions, yes.
Now, what if, for some reason, you want to keep paying a specific debt, even if it could be discharged? Maybe it's a loan from a family member, or you want to keep your car and the loan is tied to it.
That's possible through something called reaffirmation. A debtor can choose to reaffirm a dischargeable debt. This means they enter into a new, legally binding agreement with the creditor to repay that debt, even though the bankruptcy would otherwise wipe it out.
So you voluntarily agree to keep owing it.
Essentially, yes. This reaffirmation agreement has strict requirements, though. It generally has to be made before the court grants the overall discharge, and there are disclosures involved to ensure the debtor understands they don't have to do this. often used for car loans where the debtor wants to keep the vehicle.
Okay, reaffirmation. Now let's get to the payout. Once the trustee has collected all the money into the estate, how does it actually get distributed to the creditors? You mentioned a pecking order earlier.
Yes, it's a very specific hierarchy set by the Bankruptcy Code. There are basically three main categories of claims paid in this strict order. First, secured claimants. Creditors with valid perfected land as on collateral get paid first, but only up to the value of their collateral.
Okay, secured creditors first, up to the collateral value. What if they're owed more than the collateral is worth?
Good question. The remaining amount they're owed, the unsecured portion, then falls down into the category of a general unsecured creditor claim.
Got it. So, secured claims first. Who's next?
Second in line are priority claimants. This is a specific list of unsecured claims that Congress has decided should be paid ahead of other general unsecured creditors. There's a specific order within this priority group, too.
Priority claimants.
Okay.
Yeah, and after them.
Third and last in line are the general unsecured creditors who file their claims on time. These are the typical credit card debts, medical bills, unsecured personal loans, and unsecured portion of secured claims. If there's not enough money left to pay all of them in full, they share what's left on a pro rata basis, meaning proportionally based on the size of their claim.
Pro rata sharing if the money runs out. Okay. Now, this priority claimant category sounds really important. You said there's an order within that group.
Yes, there are actually 9 specific levels of priority claims laid out in the code. This is crucial for understanding who gets paid first after the secured creditors. It really reflects policy choices about what debts society deems most important to pay.
9 levels. Okay, walk us through them. This seems really insightful.
Okay, here's the basic order of priorities. 1, domestic support obligations. Top priority goes to alimony, maintenance, and child support.
Family first. Makes
Yeah.
sense.
2, administrative expenses. These are the costs of running the bankruptcy case itself, court filing fees, trustee fees and expenses, attorney's fees for the trustee or debtor approved by the court. Got to pay to keep the system running.
Right, the costs of the process itself.
3, gap claims. In an involuntary case, claims that arise in the ordinary course of the debtor's business after the case is filed but before a trustee is appointed or the order for relief is entered.
Okay, claims from that interim period in involuntary cases.
4, wage claims. Claims for wages, salaries, or commissions earned by employees within 180 days before the bankruptcy filing, but only up to a certain dollar limit per employee, currently $15,150.
Protecting employees' recent earnings up to a cap.
5, employee benefit plan contributions. Unpaid contributions to employee benefit plans arising within 180 days before filing, limited by the remaining amount of that $15,150 cap per employee after paying priority wages.
Benefits also get some priority.
6, grain farmers and fishermen claims. Special protection for grain producers or fishermen against storage or processing facilities that file bankruptcy, up to $7,475 per claimant.
Specific industry protection there.
7, consumer deposits. Claims for deposits made by individuals for the purchase, lease, or rental of property or services for personal, family, or household use that were not delivered or provided, limited to $3,350 per person.
Like paying for furniture you never got.
Exactly, that kind of thing. 8, stirring tax claims. Various unpaid taxes owed to federal, state, and local governments like income taxes, property taxes, employment taxes. The rules here are complex, but many taxes get priority.
Government taxes.
9, personal injury claims from intoxicated driving. Claims for death or personal injury resulting from the debtor operating a vehicle, vessel, or aircraft while legally intoxicated.
Wow, specific priority for DUI-related injury claims.
Yes, it reflects a strong public policy. So that's the 9-level cascade. After secured creditors are paid from their collateral, any remaining money flows down this priority list, paying each level in full before moving to the next. Whatever is left after all priorities are paid goes to the general unsecured creditors.
That's a really clear breakdown of a complex order. Thanks.
And remember, just to connect this back, payments are made according to these priority rules regardless of whether a debt is an exception to discharge, like taxes or DUI claims. The priority dictates if and how much gets paid from the estate. The discharge exception dictates whether the debtor still owes any unpaid portion after the bankruptcy case closes.
Right, so a tax might be 8th priority and non-dischargeable. It gets paid if the money reaches level 8, but if not, the debtor still owes the rest.
Precisely. The two concepts work together.
Okay, let's zoom back in on Chapter 11, the reorganization chapter, particularly for businesses trying to survive financial distress. How does that process generally work?
Chapter 11 is definitely more complex than Chapter 7. Soon after the case is filed, typically a committee of unsecured creditors is appointed by the U.S. Trustee's office. This committee usually consists of the creditors holding the 7 largest unsecured claims against the debtor who are willing to serve.
The Creditors Committee, what do they do?
Their role is pretty active. They consult with the debtor in possession, or trustee if one is appointed. They can investigate the debtor's acts and financial condition. They participate in formulating the reorganization plan, and they can make recommendations to other creditors about whether to accept or reject a proposed plan. They act as fiduciaries for all unsecured creditors.
So they represent the unsecured creditors' interests.
Exactly. And if the debtor is a corporation, sometimes an equity security holders committee might be appointed too, usually the 7 largest equity holders, to represent shareholder interests.
Though you mentioned small businesses have an option here.
Yes. Under certain provisions for small business debtors, they can elect not to have a creditors committee appointed, which can streamline the process and reduce costs for smaller reorganizations.
And as we established, the debtor generally remains in possession, right?
That's the norm in Chapter 11. The debtor in possession keeps control of the assets and continues to operate the business. The idea is that they know the business best and are usually in the best position to formulate a successful turnaround plan. A trustee is only appointed if there's evidence of fraud, dishonesty, incompetence, or gross mismanagement, or if it's otherwise in the best interest of the creditors.
Okay, so the debtor runs the show, committees watch over. This brings us to the absolute heart of Chapter 11, the reorganization plan itself. This is the roadmap out, right?
It absolutely is. The plan is the document that details how the company proposes to restructure its finances and operations and how it will treat its various creditor claims and equity interests.
Who gets to propose this plan?
Initially, the debtor has the exclusive right to file a plan. They generally have the first 120 days after the bankruptcy filing to propose their plan.
An exclusive 120-day window.
Yes. And if they file a plan within that window, they get additional time, usually up to 180 days from filing, to get that plan accepted by the creditors. If the debtor misses these deadlines, or if a trustee is appointed, then other parties like the creditors committee or even individual creditors can file their own competing plans.
Okay, so there's a race to get a viable plan out there. What goes into one of these plans?
A Chapter 11 plan has to contain specific information. It must classify all claims, like secured claims, priority claims, different groups of unsecured claims, and equity interests into separate classes.
Grouping similar claims together.
Right. It has to specify which classes of claims or interests are impaired by the plan, meaning their legal, equitable, or contractual rights are being altered, and which are unimpaired.
Impaired versus unimpaired. Key distinction.
Very key. The plan must then describe the treatment for each impaired class, how much they'll be paid, when, in what form, cash, stock, new debt, etc. It also has to provide the same treatment for all claims or interests within a particular class, unless the holder agrees to less favorable treatment. And finally, it needs to demonstrate adequate means for the plan's implementation, how the debtor will actually achieve what the plan promises.
Sounds comprehensive. Now, do the creditors just have to take whatever the plan offers? How does acceptance work?
No, the impaired classes get to vote on the plan. For a class of claims, debt, to be considered to have accepted the plan, it requires approval by creditors holding at least 2/3 in dollar amount of the allowed claims in that class that actually vote, and D more than 1/2 in number of the allowed claims in that class that vote.
2/3 amount and more than half in number, a double threshold.
Exactly. It ensures both the weight of the debt and the number of creditors are considered. For a class of interests, like shareholders, acceptance requires votes from holders of at least 2/3 in amount of the allowed interests in that class that vote. Unimpaired classes are automatically deemed to accept the plan.
Okay, so impaired classes vote. What if not everyone agrees? Can a plan still go through if some classes vote no?
Yes, potentially. This is where the cramdown comes in. After the voting, the plan goes to the bankruptcy court for confirmation. The court can confirm a plan even if one or more impaired classes have voted to reject it, provided that certain conditions are met.
Cram down. Sounds forceful.
It can be. The key requirements for a cramdown are, at least one impaired class of claims must have voted to accept the plan. This is crucial. And the court must find that the plan does not discriminate unfairly and is fair and equitable with respect to each impaired class that rejected the plan.
Fair and equitable. What does that generally mean?
It involves complex tests. but essentially means that the dissenting class is receiving at least as much as they would in a Chapter 7 liquidation, and that no junior class is receiving or keeping any property under the plan unless the dissenting senior class is paid in full. It's often called the absolute priority rule.
So junior stakeholders can't get paid unless the senior dissenting class is fully compensated.
That's the core principle of fair and equitable in this context. What's fascinating here is how the court really has to balance these competing interests to allow a viable business to reorganize, even when not everyone is happy.
It's a real balancing act. Once the court does confirm that Chapter 11 plan, either through acceptance or cram down, what's the final impact?
Confirmation is a major milestone. A confirmed Chapter 11 plan becomes legally binding on everyone involved: the debtor, all creditors, whether they accept it or not, equity holders, everyone. The debtor is then obligated to carry out the plan and make payments according to its terms.
So it replaces the old debts with the new plan obligations.
Exactly. Confirmation generally discharges the debtor from all debts that arose before the confirmation date, except for those specific debts that are not dischargeable under the code, like the wafted ones we discussed, if the debtor is an individual. The terms of the plan essentially become the new reality. And importantly, upon confirmation, the automatic stay generally terminates. The business emerges from Chapter 11 protection.
Emerges with a new financial structure. Okay. Finally, let's touch briefly on Chapter 15. You mentioned it adds an international dimension. What's its main purpose?
Chapter 15 is basically the U.S. enactment of the Model Law on Cross-Border Insolvency, which was developed by the United Nations Commission on International Trade Law, UNCITRAL. Its primary goal is to provide effective mechanisms for dealing with insolvency cases that involve debtors, assets, creditors, or other interests in more than one country.
So it helps coordinate bankruptcies that cross borders.
Precisely. It promotes cooperation between U.S. courts and foreign courts, increases legal certainty for trade and investment, ensures fair and efficient administration of cross-border insolvencies, protects the interests of all creditors and the debtor, and helps preserve the value of the debtor's assets. Think of a big multinational corporation with operations and creditors everywhere. Chapter 15 helps manage that complexity.
How does a Chapter 15 case actually start in the U.S.?
It begins when a foreign representative, someone authorized in a foreign insolvency, proceeding to administer the debtor's assets or affairs, files a petition for recognition of that foreign proceeding in a U.S. bankruptcy court.
Petition for recognition.
Yeah.
Okay.
The petition needs to prove that the foreign proceeding exists and that the petitioner is indeed the authorized foreign representative. The U.S. court then reviews this and decides whether to recognize the foreign proceeding as either a foreign main proceeding or a foreign non-main proceeding.
Main versus non-main, what's the difference?
A foreign main proceeding is one taking place in the country where the debtor has its center of main interests, or COMI, basically its headquarters or principal place of business. A foreign non-main proceeding is one taking place where the debtor merely has an establishment, like a branch office, but not its COMI.
And why does that distinction matter?
It matters because recognition as a foreign main proceeding carries significant automatic consequences in the U.S.
So if it's recognized as a foreign main proceeding, then the U.S. automatic stay we talked about earlier kicks in automatically with respect to the debtor and its U.S. assets.
Exactly. That's a powerful tool for immediately coordinating the international case and protecting assets here. Recognition as a non-main proceeding doesn't trigger the automatic stay automatically, but the court can grant similar relief on a discretionary basis.
Got it. What else can the foreign representative do once recognized?
Once recognized, the foreign representative gains access to U.S. courts. They have standing to sue and be sued. They can operate the debtor's business in the U.S. They can apply directly to the U.S. court for additional relief, like seeking turnover of assets or even commencing a full Chapter 7 or 11 case here in the U.S. if appropriate. And they can intervene in any other U.S. cases where the debtor is a party.
So they get significant powers within the U.S. legal system.
Yes, to manage the cross-border aspects effectively. Chapter 15 also includes important principles like prohibiting discrimination against foreign creditors just because they are foreign, though there are limited exceptions, like for certain foreign tax claims. And critically, it mandates that U.S. courts and U.S. trustees or other fiduciaries cooperate to the maximum extent possible with foreign courts and foreign representatives. This cooperation and communication are key to making the whole system work smoothly across borders, including ensuring foreign creditors get proper notice of U.S. proceedings.
So what this all really boils down to is that bankruptcy isn't just confined within national borders anymore. There's a sophisticated global framework designed to handle these incredibly complex international financial collapses in a more orderly and efficient way. It really shows how interconnected the modern economy is.
Absolutely. Chapter 15 is a vital piece of the modern bankruptcy landscape.
Wow. We have certainly covered a lot of ground today. We've gone from the basic types of bankruptcy like Chapter 7 and 13, figured out who can file, dug into the amazing powers of the bankruptcy trustee, navigated the payment priorities, and even explored how international cases are handled under Chapter 15. Hopefully, you now feel like you have a truly deep understanding of the mechanics.
Indeed. It's undeniably a complex area of law, but really understanding those key distinctions, like the different roles of trustees in different chapters, knowing which debts don't get discharged, and how that payment priority waterfall works, that's really crucial. Knowledge is powerful, especially when you can clearly understand and apply it, and we genuinely hope we've provided that clarity for you today.
So what does this all mean for you listening? Well, you now have the knowledge, the framework, to see beyond just the headlines when you hear about bankruptcy. You can understand the intricate legal and financial dance that's involved when individuals or businesses face overwhelming debt. And maybe for a final thought to leave you with, consider how these bankruptcy laws, which are ultimately designed to provide that fresh start, are constantly engaged in this delicate balancing act. They're trying to balance the needs of the debtor seeking relief, the rights of the creditors trying to recover what they're owed, and the overall health and stability of the economy. It's a constant tension, isn't it? Always being adjusted and debated.
A fascinating tension, absolutely.
Thank you so much for joining us on this deep dive into bankruptcy. We really enjoyed breaking down these complex sources and sharing these nuggets of knowledge with you. We're already looking forward to unpacking another fascinating topic with you next time.